Juris Vodcast with Scott Pearce.
It's okay to run a for-profit fantasy baseball league without paying Major League Baseball for the right to use the names and statistics of big league ball players. The Supreme Court has declined to hear a case on this point. That means an Eighth Circuit decision is going to be allowed to stand. The players' names and their statistics are in the public domain. That's the reason why no license is required for the commercial use of that information. The fantasy baseball leagues have First Amendment free speech rights to discuss and analyze this information. These are more important than Major League Baseball's right to control the uses of the information their business generates. This case arises out of the state law of Missouri. For Major League Baseball to prevail, it would have to show that the Fantasy League was using the names of the players as a symbol of the league's identity without consent and to gain a commercial advantage. The parties stipulated that the use was without consent, but the Eighth Circuit said that the other elements were not satisfied. The court's analysis is interesting. Merely identifying the players doesn't constitute commercial use. The league is not implying any endorsement on the part of the players. The ironic fact is that CBC, the company that operates the fantasy leagues, previously paid a licensing fee for the use of the players' names and their statistics. Major League Baseball refused to renew this license when it expired, and it offered to pay CBC a commission if CBC referred customers to a fantasy league operated by Major League Baseball. CBC went to court rather than shut down its own business. I like this court decision. Information like baseball statistics routinely published in the newspapers obviously is in the public domain.
Juris Vodcast is a production of Nuclear Podcasting. Creative Commons Attribution Non-Commercial No Derivatives.